We will go on the record in the matter 25 CF 147, State of Wisconsin versus Rita Wenzel. The state appears through District Attorney Kevin Schmidt in person. Ms. Wenzel appears in person with counsel Nicholas White. We're set here today in this matter for a plea hearing. The parties have reached an agreement. Mr. White, I'm going to have you place that agreement on the record, please.
Understood, Your Honor. The agreement here is that the state will move to amend the current charge down one notch from a Class E felony to a Class F felony. It's a pretty straightforward agreement. We're both asking for a PSI to be ordered here, where parties would be free to argue at sentencing. And the vehicle that was seized here and was in the amended criminal complaint would be released as part of the plea deal. That's the agreement, Your Honor. I emailed Attorney Villard about whether or not there'd be a position from the state on bond. I know sometimes on a serious case like this, bond is revoked. I didn't get an answer, and I have an argument against that if that's something that Your Honor is considering. That's the full plea deal. I can give you the plea questionnaire now.
Thank you. Please bring it forward. Thank you. There's 5,000 cash, right? All right, Ms. Wenzel, is that the agreement that you've reached with the state?
Yes.
And you're gonna have to speak up because my court reporter is gonna need to be able to hear everything, okay?
Yes, Your Honor.
Mr. Schmidt, formal motion to amend to a class lower to a Class F felony.
So made.
Granted. Ms. Wenzel, do you recognize this document that I have in front of me?
Yes, Your Honor.
That's the plea questionnaire waiver of rights document. Did you sign this document?
Yes, Your Honor.
Did your attorney thoroughly go over this document with you?
Yes, Your Honor.
Did he essentially go over it with you word for word?
Yes, Your Honor.
Do you understand everything completely?
Yes, Your Honor.
If you didn't understand something, did you ask him to explain it to you?
Yes, Your Honor.
And he did so.
Yes, Your Honor.
You're 57 years old, 12 years of schooling. You have an HSED. You can read, write, and understand the English language. All correct.
Yes, Your Honor.
You are not receiving treatment for a mental illness or disorder, and you have not had any alcohol, medications, or drugs in the last 24 hours.
Yes, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on the first page. Did your attorney thoroughly go over those rights with you?
Yes, Your Honor.
You understand them completely.
Yes, Your Honor.
I'm going to briefly go over them with you to ensure that you understand them. Do you understand you have the right to a trial? You would
Yes,
have
Your
the
Honor.
right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial with 12 of your peers who would need to reach a unanimous decision as to a guilty verdict or find you not guilty. You would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights that you're giving up here today?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes, Your Honor.
You will not be able to vote in any election until your civil rights are restored.
Yes, Your Honor.
Do you understand here that the state would have to prove on or around September 19th, 2025, in Burnett County, Wisconsin, you did deliver a controlled substance, to wit, methamphetamine, and now in an amount less than 3 grams. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty is a fine of up to $25,000 or 12 and a half years of incarceration or both?
Yes, Your Honor.
Do you understand that pursuant to the agreement, the court will order a pre-sentence investigation report.
Yes, Your Honor.
And do you understand what that report is?
Yes, Your Honor.
That report, so you are aware, it contains a whole lot of information about you, about your life, your history. It also will have a recommendation as to sentencing from the Department of Corrections standpoint. Do you understand? I'm not bound to follow that recommendation.
Yes, Your Honor.
You understand this is a free to argue, so that means I'm not bound to follow the state's recommendation or your attorney's recommendation.
Yes, Your Honor.
I would be free to sentence you to what I believe is an appropriate sentence based upon the facts of this case and the information in the pre-sentence investigation report. Do you understand that?
Yes, Your Honor.
Did your attorney thoroughly go over the criminal complaint with you?
Yes, Your Honor.
In particular, did he go over that probable cause section where it basically says what happened and why you were charged with the crime?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty to delivering methamphetamine because you are guilty?
Yes, Your Honor.
Mr. White, may the court use the probable cause section of the criminal complaint with the statement made by your client to find a factual basis?
Yes, you may, Your Honor. We stipulate.
Has anyone made any threats or any promises to you for you to plead guilty today?
No, Your Honor.
You're doing so freely and intelligently. That means you are telling me that you fully understand what you're doing.
Yes, sir. Your Honor.
And voluntarily.
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
Now, has he looked at the discovery, which is the evidence of this case, and has he discussed that with you?
Yes, Your Honor.
Has he discussed the potential for any legal defenses or a lack of legal defenses in this case with
Yes.
you?
Yes, Your Honor.
Have you discussed with him every fact that you know to exist about this case?
Yes, Your Honor.
Have you discussed with him a potential for any other pertinent facts, such as any alibi or any other person who may be responsible instead of you or with you?
Yes, Your Honor.
Are you satisfied with his services?
Yes, Your Honor.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
Now, Mr. White, do you believe that your client is entering a plea here freely, intelligently, and voluntarily?
Yes, I do, Your Honor.
Do you believe that she is competent here today to enter a plea?
Yes, I do.
Do you believe she fully understands her constitutional rights and what she is giving up?
Yes, I do.
Did you fully explain to her and go over what the state would have to prove with the elements of the crime, with the facts of the case as they exist?
Yes, Your Honor. We spent some time reviewing the jury instruction, and I know we've also reviewed the discovery. Importantly, that's the body camera, or it was a video that was part of it.
Do you believe she understands the maximum possible penalties that she faces?
Yes, I do.
And do you believe that she understands the pre-sentence investigation report and what that means?
Yes, I do.
Is there any reason why I should not take her plea here today?
No, Your Honor.
As to the amended count of delivery of methamphetamine under 3 grams, a class F felony, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of delivering methamphetamine, a class F felony. A judgment of conviction will be entered today. The court will order a pre-sentence investigation report, long form. Agent does not need to appear, but should be readily available by telephone if questions arise. As to whether or not to revoke bail bond, Mr. Schmidt.
I would ask the court to revoke the bail bond in this case. I appreciate that this is a person who only has a few prior convictions and that she's made her court appearances since her cash bond was reduced to $5,000. That being said, now that she's entered a plea to an offense that more often than not yields a prison sentence, and I think she's well aware of that. And an offense that has a potential for a significantly high penalty, with the state free to argue, I worry greatly that the fear that could lead to her not coming to court in the future is much greater. That is the primary reason why. Thank you.
Thank you. Mr. White.
Thanks, Your Honor. I believe the only criminal history here that I can see on CCAP is a handful of misdemeanors. Importantly, a 2012 drug possession charge that was reduced when she completed treatment court. I would ultimately ask Your Honor to consider the same issues that I raised and argued at the bond hearing that was on January 29th. The court lowered the bond from $10,000 to $5,000 after Ms. Wenzel was in the jail for over 3 months. I'm not going to repeat those same arguments today, but the point is that, Your Honor, you trusted her then. If that bond money was posted, that she would return, and she's done that today. I think that she can be trusted to return for sentencing. She does have some questions about how the PSI would actually go. I think that that's just a process that somebody learns as they do it, where to report and that kind of thing. But she is on the hook for the $5,000 that was posted. When she was in custody, she told me what her plan was when she was released. And since then, she's followed up on that exact plan. She's been sober for 8 months since October. Prior to this incident, there's been no new charges, no bond violations. I think that she has the stability that's required for expecting a person to return and face what could amount to a prison sentence. I say that because she owns a home where her daughter and their boyfriend is living at. She's been able to find a job almost immediately after she was released from jail. It started off as part-term or part-time, and then now as a full-time job. She's been meeting with the county for the FSEP program. She got an HSED in February, and she did an AODA in Spooner, I think around the same time. She's been making her meetings. She's been doing NA or anonymous meetings. And I think that goes to her stability. The other part of it is that she holds herself accountable. She showed up today knowing that a PSI might not have been ordered. She might have been facing a prison sentence today. But with us asking for the PSI, we'll be able to know a lot more about her once that's done. And I know that she's going to report to do those meetings. So long as she's compliant with the PSI process and she returns to court, I don't think there's any need for the bond being revoked. Thank you, Judge.
Thank you. Ms. Wenzel, do you understand the seriousness of the offense that you just pled guilty to?
Yes, Your Honor.
And you admitted that you are guilty of delivering methamphetamine, is that correct?
Yes, Your Honor.
And you viewed the video that purports you to be selling methamphetamine to a confidential informant, is that correct?
Yes, Your Honor.
And do you understand that this could be a potential prison sentence?
Yes, Your Honor.
Do you swear to the court that if the court were to entertain allowing the bond to continue until sentencing, that you will come to court no matter what the PSI recommendation is?
Yes, Your Honor.
You own your home.
Yes, Your Honor.
Are you willing to pledge your home to ensure that you will come to court?
Yes, Your Honor.
Ms. Wenzel, this is a very serious crime, and now there is a high potential. I don't know for sure. I don't have the pre-sentence investigation report or arguments from either attorney, but there is a possibility that this could be a prison sentence. So it makes it extremely serious. You have a lot going for you on the positive side. You are a Burnett County resident. You've been living here for almost all your life, I think. Your children live here, your grandchildren live here, you own your house here. Everything is here. You have a job. I believe this is your mother
Yeah,
who's here present with you today. Your mother is here. $5,000 is a lot to lose, right?
yes, Your Honor.
Having $5,000 lost as well as losing your house is a lot to lose.
Yes,
Right.
Your Honor.
I'm going to give you a chance and I will allow you to remain on bail bond. Any violation whatsoever, any violation at all of the criminal nature, not a traffic ticket or something like that, unless it's an OWI. Any violation means that the court will revoke bond just on the notification that you violated. Do you understand?
Yes, Your Honor.
And with that, with a revocation and with a violation of your bond conditions, the court shall forfeit your bail pursuant to 969.13 of the Wisconsin statutes. Do you understand that?
Yes, Your Honor.
You will come to court on the sentencing date. Is that correct?
Yes, Your Honor.
If not, do you understand that the court can issue a warrant that is extraditable from anywhere across the world?
Yes, Your Honor.
I will not revoke, but I will set it for sentencing. I know this is not your case, Mr. Schmidt, but would you have an idea of an amount of time to set it for,
An hour or less.
Mr. White?
I think an hour is appropriate.
All right, I have August 3rd, anytime from 9 to noon, so we can do 9 o'clock, 10 o'clock, or 11 o'clock,
Your Honor, I'm busy that day in Barron County.
the whole day.
Yeah, I think you asked me that this morning too, and still
Oh, I
busy.
probably did. How about July 23rd at 11?
I won't be able to make that in person. I'm in St. Croix County that morning.
August 31st at 2?
That'll work for us, Your Honor.
That is a very long time, and that is a lot longer than I would usually go out, but the summer calendar is quite full, especially on certain weeks. So August 31st it is. We will see you then. The court is also ordering here today that the vehicle shall be released back to Ms. Wenzel pursuant to the agreement. You must follow every single condition of your bond, every single condition.
Yes, Your Honor.
All right. And do you understand that if you violate any condition of bond, not only does it mean that the court will revoke your bail bond and forfeit the cash and potentially your house, but Mr. Schmidt he would be in a position where he would not need to follow the recommendation.
Yes, Your
Well,
Honor.
I guess it's free to argue anyway, so it doesn't really matter. So, and it's Mr. Vila anyway, too. So, but do you understand all of those things?
Yes, Your Honor.
All right, thank you. Then we are adjourned.
Thank you, Your Honor.